Valuation date that he has used is the 14th of March, which, as I said, is the day before the moratorium was announced. And we get that date by going back to Article 13.1 of the ECT, which speaks not only of the date immediately before the expropriation, but also the date of the impending expropriation, when that became known in such a way as to affect the value of the investments. And if you look at Mr. Kaczmarek's, I think it's first report, paragraph 10 on page 9, he explains that from an economic point of view, the 14th of March is the correct valuation date. Now, the 11th of March date that you mentioned, Mr. Chairman, I think is used by Mr. Kaczmarek in doing some price projections. But the valuation date is the 14th of March. In light of some arguments that have been made by Germany, I think it's important to note in this context that what he has done is a comparison of actual values and values but for the measures, not but for Fukushima, as has been suggested by Germany from time to time. The Fukushima accident has in fact been taken into account by Mr. Kaczmarek in making his calculations, both in the but-for and actual scenarios. The difference between the actual and but-for lies in the measures that Germany has taken. I mean, the immediate shutdown of the 7 old plants and the criminal plant, the revocation of the new volumes, the implementation of the nuclear fuel tax, the establishment of fixed shutdown dates, and so forth. That explains the difference between the but-for and the actual scenarios or values. Before turning to the actual plants, there is one aspect which should be mentioned, I think, and that is that the fair market value of a nuclear power plant is quite different from the value of most other assets, since it changes over the life of the plant. There are very large negative cash flows while the plant is being constructed, followed by a substantial positive cash flow while the plant is up and running and making money. Then finally, and this is the truly unique part for a nuclear power plant, at the end of the plant's operating life, it incurs decades of quite substantial negative cash flows as the plant is being decommissioned. And the nuclear waste is moved to final storage, as was briefly mentioned in the film we saw about criminal. For example, the decommission cost for the criminal plant in the but-for scenario was estimated to around 5 billion euro over a period of 60 years. So it's a bit different valuing a nuclear power plant and the business of a nuclear power plant operator than doing the sort of more traditional valuation in investment treaty cases.
Professor Berg, so about the decommissioning, does that depend on how it is funded? Some wait until the end, others start already at the beginning, nuclear power plants in funding for decommissioning.
That may well be the case, but I mean, they are, I assume under German law as under most legal systems, under an obligation to make sure that they can decommission, and how they finance that might vary.
In the form, what I read in your case here, in the form of provisioning every year.
Yes.
That it did.
Yes.
Okay.
I mean, the actual, I mean, you have provisions in the financial statements on an annual basis, but the actual cash outflows, of course, happens only when you de facto start to decommission. So if we then move on to the first plant that I'm going to talk about, that's the criminal plant. But for the measures, criminal, and we start with the but-for scenario, but for the the measures, Krümmel would have restarted operations in January 2012 and produced electricity by using its electricity production volumes, i.e. the OEPVs and the NEPVs. As you can see on the slide, there was no fixed end date for the operation of the plant, but Krümmel can be estimated to have run out of volumes, we say, in 2033. Thereafter, the plant would have been decommissioned, as I said, which would have included work and cost throughout 2093, i.e. for 60 years. On this slide, we have described in a rather generalized way how Mr. Kaczmarek has in fact calculated the value. I mean, you look at the total revenues, total costs, net income, and so on and so forth. So let me just go through these in a rather general way. Revenues in the but-for scenario would have come from the sale of electricity, obviously. These revenues we get by multiplying the volume of electricity generated, the megawatt hours, by the unit sales price of electricity, i.e. euro per hour. The annual electricity produced by Krümmel we get by multiplying the electric power output, which in the case of Krümmel was 1,346 megawatt, by the number of hours that the plant is expected to operate in each year. Mr. Kaczmarek has used an average effective utilization rate, as you can see, of 83%, which means roughly then about 7,300 operating hours per year. By multiplying those operating hours with the power output, we get an average power generated of approximately 10 terawatt hours per year. That's on the production side, so to speak. If we then go to the sales price of electricity, Mr. Kaczmarek has, for the first 6 years of his calculation, relied on German wholesale futures market prices. I mean, for base load electricity prices. These are reported on something called the European Electricity Exchange. He has had those prices available until 2017, and thereafter he has assumed that prices will be more or less constant in real terms, in other words, grow at inflation. Over the remaining operative lifetime then of Krümmel, these factors combined, so to speak, would have resulted in total revenues of 13.8 billion. That's the income side. If we look at the cost side, we have listed the main costs, and these are operating expenses, depreciation, decommissioning, other costs, and taxes. And the largest group there, as you can see, are the operating expenses, which in turn fall into two further groups, namely maintenance costs and payments to the Renewable Energy Fund. As far as maintenance costs are concerned, Vattenfall has, as part of its budgeting process, prepared detailed forecasts of the costs that they would have incurred or should have incurred over the remaining operating life of the plant, and Mr. Kaczmarek has relied on those numbers when he's made his calculation. And I mean, the payments to Renewable Fund were then based on the development fund agreement that we've talked about previously. Depreciation is another major cost item, includes depreciation on capital expenditures. And again, Vattenfall has prepared a detailed projection of capital expenditure for budgeting purposes. during the ordinary course of business, and Mr. Kaczmarek again has relied on those calculations when he's made his calculations. I should also add that the depreciation costs have been scrutinized by some of claimant's experts in this arbitration, namely Mr. Charles, Mr. Bolke, and Dr. Blesich. The third largest, in fact the second largest cost item is decommissioning. As I said, the way it works is that the actual expenses, cash flows, are incurred once the plant is shut down and is being decommissioned, but the costs are recognized in the books during the operating life of the plant. The number here we're using includes only those decommissioning costs that are recognized during the operative years. And again, Vattenfall has, of course, has been required to prepare decommissioning cash flow projections as part of its business. And that's again what Mr. Kaczmarek has used in his calculations. So if we sum up the total costs, we get 11.5 billion, which results in an undiscounted net income of 2.22 billion. To arrive then at the positive cash flow from the operations, non-cash costs, non-cash items such as depreciation and provisions are added back to the net income, which leads then to positive cash flow of 3.97 billion. Then we have to add negative cash flows from decommissioning. During the course of 60 years, the total amount undiscounted is, as I said, almost 5, to be exact, 4.8 billion euro. And when you apply the discount rate to this, you get eventually the value of the plant in the but-for scenario, which is 1.469 billion euro that you see at the bottom of this slide. Now, as far as the discount rate is concerned, Mr. Kaczmarek has used, as is customary nowadays, the WACC, the weighted average cost of capital, and he has determined that the relevant discount rate here is 6.52%. So that's how we get to the but-for value of the Krümmel plant. If we move on then to the actual scenario for the Krümmel plant, well, of course, here the Krümmel plant has been immediately and permanently shut down. It's unable to restart and generate any positive cash flow. So the value in this scenario is simply equal to the present value of the future decommissioning cash outflows. That's a big number, as you can see. And as I mentioned before, Vattenfall has prepared detailed projections of decommissioning costs for financial reporting purposes, as usual, scrutinized by auditors and by independent third-party experts, and Mr. Kaczmarek has used those in his calculations. So applying then to the decommissioning cash flows, again the relevant discount rate, which is 6.52, we get a total value of 1.639 billion euro. And if you add that to the but-for number, total diminution in value, so to speak, is 3.108 billion euro. Now, in relation to Krümmel, in the actual scenario, it should also be mentioned that the plant is left with 88 terawatt hours of stranded old volumes, which we'll come back to. 88 terawatt hours of OEPV. And of course, any money that can be generated by commercializing these volumes can be used to offset claimant's damages. However, as Mr. Kaczmarek explains more in detail in his reports, there is essentially no market for OEPVs in the actual scenario, in particular since the supply will be significantly greater than the demand. And this is, we say, a natural, as has been described today, this is a natural consequence of the decisions taken within the framework of the 13th Amendment. So Mr. Casimir concludes that the OEPVs are worth zero today. That notwithstanding, the claimants are prepared to issue, with respect to the OEPVs, an irrevocable offer for Germany to sign a trustee to try to sell the OEPV and turn over any proceeds to Germany. If I move on then to the second plant that we're going to look at, namely the Bruckdorf plant. And here the methodology is more or less, well, is the same as we used in with respect to Krümmel. There are some differences. The Bruckdorf plant had a higher, or has a higher output and utilization rate than Krümmel, as you can see. 1.4 megawatt hour, 89% utilization rate, so on and so forth. It has somewhat higher costs to operate the plant, 12.3 billion, and somewhat higher negative cash flows from decommissioning. But using the same methodology here in the but-for scenario, we get a value of 2.1 billion. In the actual scenario, Bruckdorf is still operating. Compared to the but-for situation, there are three differences to be noted here in the actual scenario. First of all, Bruckdorf has lost the new production volumes, the NEPVs. There is a fixed shutdown date, which is 2021, and Bruckdorf is paying the nuclear fuel tax. As far as the NEPVs are concerned, it's worth noting also that when the 13th Amendment was adopted, the plant had a total volume of 237 terawatt hours. Of those, 146 were NEPVs. That means that when the NEPVs, the new volumes, were revoked, Bruckdorf lost more than 60% of its available volumes. And already that, we say, indicate a quite substantial loss. The nuclear fuel tax that Bruckdorf is paid during the period of 2011-2016 and is part of the fuel costs for that plant. I should also note that even though 2021 is the fixed end date for that plant, the calculations show that it would probably have ceased operation in 2019 when they run out of production volumes. As a result of decreased revenues, added nuclear fuel tax, accelerated decommissioning costs, the actual value of the Bruckdorf plant in our calculations is 345 million euro.
So, can you help me here? So you just said that Bruckdorf will run out of its production volumes in 2019. Could it then not buy the production volumes from, what is it, the other one, Krümmel? But you say that they are unsaleable?
They are indeed, well, yes, that is a possibility, I suppose. I'm not quite sure right now how that has been factored in by Mr. Kazmarek in his calculation, so I think we'll have to consult with him to come up with an answer. Yeah.
I asked a question on your own case. It's not something I invented.
I do appreciate that. If I may then go on to the third plant that we're talking about here, the Brunsbüttel plant. And again, we start with the but-for scenario. But before we do that, there is a major difference between this plant and the two other plants, in the sense that here we're not actually valuing the plant as such, but the remaining production volumes of the Brunsbüttel plant. On this point, Mr. Kaczmarek and Ms. Hardin, Germany's expert, seem to be in agreement, i.e. that it would have been more economical for this plant actually to sell the volumes rather than trying to start up the plant and use the volumes themselves. So that is why we're using a different, well, the valuation method is the same in the sense that we're using the but-for and the actual scenario, but we're not looking at the plant. So if we start then with the but-for scenario with respect to the Brunsbüttel plant volumes. In the but-for scenario, the Brunsbüttel plant would have had 11 terawatt hours of old volumes and 41 terawatt hours of new volumes, i.e. a total of 52 volumes. Uh, 52 terawatt hours, sorry. As Mr. Kaczmarek has explained in his report, there would have been a ready demand for these production volumes. There were no hard shutdown dates for any plants in the but-for scenario. The plants could continue operating as long as they had producing production volumes, and they would have had an incentive to continue to operate, since it would have obviously increased revenues and deferred the commission costs. Mr. Kaczmarek's analysis also shows that there would have been limited supply. The Brunsbüttel volumes would in all likelihood have been the only volumes available for purchase in the but-for scenario. So many potential buyers and one seller. This is very different from the situation that exists today, as a matter of fact, for the Brunsbüttel volumes, where there are many sellers but only a few buyers. Now, to value these volumes, Mr. Kaczmarek has first forecasted the time at which other plants would have needed to purchase additional volumes. The forecast projects each plant's future electricity production based on historic average utilization. Mr. Kaczmarek has concluded that 4 plants would have had a demand to use the volumes during the period 2020 to 22. These 4 plants are Isar 1, Felixburg 1, Neckar-Westheim 1, and Unterweser. In this scenario, since there is really no uncertainty as to whether the volumes could be utilized, the plants would be willing to buy these volumes already in 2011. That's the basis for Mr. Kaczmarek's calculation. Bought in 2011 to be used in 2020 to 22. In determining the price that Brunsbüttel could achieve from the sales, there are no relevant historical transactions to compare to. So Mr. Kaczmarek has relied on a discounted cash flow method, as would buyers do, buyers of volumes do to assess how much they would be willing to pay. No specific data of buying plants has been available, so Mr. Kaczmarek has used the Krümmel and the Bruckdorf plants as proxies and applied an average of the values from the 2 plants. So that's the methodology that he has used to try to calculate the but-for value of the volumes in this scenario. When it comes to the price, then his conclusion is that for the old volumes, they could have been sold at 31 euro per megawatt hour, and the new volumes at 19.8 euro per megawatt hour. Results in undiscounted revenues of 1.63 billion. And using the discount rate again, 6.52%, we end up with 841 million euro in the but-for scenario. In the actual scenario, Brunsbüttel's license, of course, has been revoked. But just as in the but-for scenario, the valuation is made not of the plant as an operating asset, but of the plant's production volumes. In the actual scenario, Brunsbüttel has been deprived of its new volumes. This was 41 terawatt hours of the plant's total of 52. This is a revocation of 79% of the volumes. Again, already that a considerable loss. However, in Mr. Kaczmarek's calculations, there is no foreseeable market for the remaining 11 terawatt hours of old volumes. So his conclusion is in the actual scenario that the volumes are worth €0. No value at all to be attached to them. And it should perhaps be mentioned in this context that Germany's expert, Ms. Hardin, agrees that the Brunsbüttel volumes were negatively affected by the measures. We get that from table 29 in her second report. We don't need to look at that now. And furthermore, when she applies historical utilization rates to calculate production of volumes, rather than the reference production volumes, the RPVs that were mentioned earlier today, when she uses historical utilization rates, she comes to the conclusion as well that the Brunsbüttel volumes are worth 0 in the actual scenario. If you look at the table we have up there, which is table 40 from her second report. We will come back to this concept of reference production volumes and historical utilization rates when we listen to Mr. Kaczmarek. So, in conclusion, then, if we take a look at the next slide, we summarize the total diminution in value. And this, basically, so to speak, corresponds to our claims, but not quite, because there are some differences here. Between Brunsbüttel, with respect to Brunsbüttel, there is no difference. The amount you see on the slide is the amount that we're claiming. For Krümmel, the actually claimed amount is slightly lower than what you see on the slide. And that's because Mr. Kaczmarek has made some adjustments for tax and for some salvage parts that the plant has been able to sell. For Bruckdorf, of course, there's a considerable difference because we're claiming only for 20% corresponding to our share, or to the claimant's share in Bruckdorf. So those are the calculations on which we rely in support of our claims for damages. I should also say at this stage, perhaps a few words about the report that has been submitted by the respondent, i.e. the reports, I should say, submitted by Ms. Hardin. We have asked Mr. Kaczmarek to quantify the damages that claimants have suffered as a result of the measures. The outcome is what we've seen, what we talked about. He has applied an ex-ante fair market valuation method to calculate the damages. His calculation, of course, is based on our positive case, our positive legal case. In fact, he has also included in his report what we call switches in an Excel model, which make it possible for you to calculate alternative outcomes should you not agree with us 100%. That's all in his report. Germany, however, has not offered any ex-ante damages calculation to serve as an alternative to Mr. Kaczmarek's calculation. Germany has expressly noted that it did not ask its experts to perform a calculation of Vattenfall's alleged damages. They have asked its expert, Ms. Hardin, to perform a non-responsive so-called impact assessment. And they have been very careful to stress that such an impact assessment is different from a damages calculation. The idea seems to be that Germany wants Ms. Hardin to conclude that there has been no adverse financial impact, and then argue that there needs to be such an impact in order for there to be a breach of the ECT. We get that from the counter-memorial paragraph 441, where the respondent says, in case of the 13th Amendment, the analysis shows that the measures did not have an adverse financial impact on Vattenfall. Failing such impact, there cannot be a breach. We have submitted or explained now submissions that there is simply no support for that kind of an approach. And what is more, Germany has instructed Ms. Hardin to disregard basically all fundamental aspects of our positive case when she is making her calculation or assessment. She, in her second report, which you see on the slide, an excerpt from in section 723, she says that my analysis is based on the legal instructions that the claimant's interests were not expropriated, that the NFT is not subject to jurisdiction of the tribunal, that the revocation of the LTEs are not breaches of the ECT, and that the tribunal does not have jurisdiction over the claims of Krümmel and Brunsbüttel. So the question is, what is she actually doing?
You have 1 minute left.
Sorry?
You have 1 minute left.
Very good.
With that question.
She has been asked to make an assessment of the impact of our breach of breaches made, we say, by Germany. And in doing so, she is assuming away all the breaches. So one wonders what is left of her report. We say nothing. It's nothing that is very helpful to the tribunal. So that concludes our opening statement. Thank you.
I do have a question, if I may. Could you please go back to slide 98? And that's the slide about the prayers for relief.
Okay.
And you explained to us your principal claim, and you put them in the alternative, but your principal claim is that you claim for Krümmel and Brunsbüttel 100%.
Yes.
correct? So could you help me, because you say that you base that on control. Could you, but if you would base it on shareholding, then you come in your first alternative claim, isn't it? Or your second, actually, depending where you look at it. Could you help me? Why is it that you rely on control rather than on shareholding? And I'll give you an example why I ask this question, a very simple one. If I have a 50% shareholding in a company, I get 50% of the available dividends, not 100%. Unless there's a special arrangement, if I have special types of shares. Why is that different in your submission? And maybe the comparison with dividends is not appropriate. But could you explain me why you make this distinction?
These alternative claims that we presented are in response to objections made by Germany. Yeah. So in case you accept some of their jurisdictional objections, we have prepared alternative claims. But our primary claim, is that Krümmel, Brunsbüttel are claimants in their own rights. So they claim for 100% of the damages that they have been afflicted. And that's item number one. That's our primary claim. And Vattenfall Nuclear, being the 20% shareholder of Bruckdorf, is claiming for that share, so to speak.
It goes back actually to one of the first questions you had this morning about the shareholding and what's the investment. Right, but you may have then the situation that you get 100%, whereas, for example, for Brunsbüttel, whereas there's only a shareholding for 66.7% by Vattenfall Europe, and E.ON has the other shareholding.
Because the damages inflicted on Brunsbüttel, they are what they are. And since the ECT is structured in such a way that is based on control, as you well know, a local incorporated company but controlled by a non-local company is an investor under the treaty and thus a claimant. And that is in that capacity that Krümmel and Brunsbüttel are claimants here. Yeah, but so that has nothing to do with the shareholdings.
I can see that. Okay, you are good.
I'm sorry, don't you add that with respect to Krümmel and Brunsbüttel, you manage the plants? And that's your key, I think.
Okay. We are, I think, what is called in German a managing shareholder, plus that we have a power attorney to represent. So I say that again, the shareholdings in our primary case, that they are irrelevant, we say, for the damages. The reason why we are using the percentages here is to present to you alternative claims should you agree with some of the jurisdiction objections made by the respondent.
As a point.
Has that to do with because finally these plants could be considered a kind of tolling plants?
What?
Tolling plants.
No.
TOL and G. Because what you do is it is only a cost-sharing arrangement for these plants, isn't it?
Yes, but I'm not quite sure how that is relevant for.
But I'm still at loss here, and you have to help me. Is that what might happen here is that you get 100% of the damages for Brunsbüttel, whereas E.ON go also after the government or the state and say, well, look, I have here still some, 33 point something in shares, and I also have damages.
That's the question I've got too. And on your approach, could E.ON make a claim for 100% of the damages to Brockdorf on the basis that they control it?
could we start first with the Krummel plant and then, with the Brunsbüttel plant and then Brockdorf? With Brockdorf, you're claiming only 20%. For Brockdorf, you're claiming only 20%. Is that correct? Yeah. Okay, but there the problem is.
Well, it's not, because the question is whether the approaches between Brockdorf and the other two are consistent, or whether you're adopting different approaches to the different plants.
Well, I mean, we are clearly adopting, I mean, since the claims are different. I mean, maybe I'm misunderstanding your question, but I mean, Krummel and Brunsbüttel, they are, as we say, claimants in their own rights, and in their own right, and so they are asking for. We are asking for the total damage, whatever that is, that they have been suffering.
But my question is still there, and I think it does go to the treatment of the other two. And if E.ON were non-German foreign controller, could it claim 100% of the damages to Brockdorf on your basis, even though they only own 80% of the shares?
Yeah, I mean, as a matter of principle, yes, I think so.
So if they could claim 100%, on what basis
100%
can you claim
100%
20% now?
I mean, each claimant/investor under the ECT obviously has to prove their losses. And I mean, in so doing, there is no unbreakable link between shareholdings and the companies in question.
The answer, at least in part to this, is they are in this case because of a combination of Article 26(7) of the ECT and Article 25(2)(b) of the ICSID Convention. So because by virtue of foreign control, which in those cases involves the operating control as the 50% holder, and the other case it's different, they get the whole bunch. They may have an obligation under applicable law to render, I mean, vis-a-vis E.ON, to render some of that to E.ON. That's your structure, I think.
Yes, and I think, I mean, we're getting perhaps into, I don't know, a theoretical discussion here, but I mean, the ECT doesn't really solve these issues, and we can say this is bad or not, but I mean, you will not find the answer the way, I mean, you're putting the question, Mr. Chairman, to your, I mean, the answer is not to be found in the ECT. I think the ECT, you know, we must use it, you and we must use it as a treaty interpreted under the Vienna Convention, and it may well be that it does not have answers to all the questions. And I think one of the answers you will not find in the ECT is how to deal with shareholdings.
I see your point, because what you were saying is claimants 4 and 5, if I may call it that way, claim in their own right, because they, in your submission they fall under the treaty. Okay. But
we have made quite substantial submissions on that, and I mean, as you know, I mean, Professor Schroyer has explained that in his opinions, that the combination of, I think it's 26(7) of the ECT and Article 25(b) 2b of the ICSID Convention gives this result.
The question that still remains is that whether you can also that translate into damages in quantum. Okay, but let's put that for I will almost say another day, but that is not the case. It's another afternoon. Let's have lunch now, I would suggest. And can we reconvene? How much time do you need for lunch, Dr. Conrad and your team?
I think on my part, I would say So long as the aircon will take to be shut off, because otherwise I will be freezing. But an hour should be absolutely fine.
Shall we?
If we are faster, we can.
No, let's have a
resume earlier.
fixed time, 3:30. Okay.
By the way, we have now received Professor Dolce's CV, so we will transfer that to.
Okay, and also the information of Mr. Kaczmarek about his Excel sheet.
You said after lunch? And
I said after lunch, but...
I'm sorry, yeah, and that's a bit of a housekeeping matter, I forgot. If we can go to slide 107 of Clayman's presentation, and bear in mind the figures you've just seen on 98, which has been on the screen. 107 shows that the figures are already different. And I believe Professor Hobert said he relied on the corrected calculations of Mr. Kaczmarek. That's ample proof that those calculations are already in existence. We asked for them yesterday after they were offered. We didn't get them. This morning they wanted to defer until Tuesday, then until lunchtime. Now they say after lunch. I think we have a pattern here.
No. Dr. Conrad, my order was after lunch, but I thought I could grab here the opportunity, hearing that also the CV of Professor Dolce is here, that we also may have more information on Mr. Kaczmarek, but that's not the case. So, right after lunch at 3:30, we have the answer.